Hi, I'm Matt Culkin, co-chair of Steptoe's Financial Services Group, and welcome to another episode of Steptoe's Financial Services University. We're pleased to present a series of short, focused conversations with my colleagues from across our firm's practice groups and offices around the world. Today, we're going to talk about distressed asset acquisition, what to do with distressed assets, and how to get rid of them. I'm joined by my colleague, Jeff Reisner, resident in our Los Angeles and New York office. Jeff, thanks for joining me.
My pleasure. Nice to be here.
So to start, I thought it would be helpful if you just described your practice, but in case you don't, I want to plug, you've done two recent webinars on the firm's website, one specifically focused on distressed asset acquisitions and a separate one on Bankruptcy 101. And I want to make sure our audience is able to see those, so we've linked to them on the Financial Services University page. But with that, I'll let you introduce yourself to the audience.
Hi again, thank you. My name is Jeff Reisner. I'm a partner in the Transactions Group. We have a much longer name that I don't use. And I lead our insolvency and restructuring practice globally. I'm, as we heard, resident in New York and Los Angeles. I represent debtors, creditors committees, acquirers, sellers, trustees, and informal and formal groups in bankruptcy proceedings throughout the country and in out-of-court proceedings as well.
So with that, maybe let's jump right in. So we're talking about distressed assets. Why would you want to avoid the sale of a distressed asset through a court proceeding?
Okay, well, court proceedings have some negatives associated with them. There's a perception of a perceived price advantage by buying a distressed asset outside of a court proceeding, and that's because it's necessarily advertised less and under less scrutiny. Out of court is also less expensive, not only for the negotiation of the actual agreement, but for prosecution of the case. It doesn't require a bankruptcy case around it, which can be expensive and slow. There's also a view of less competition, and the asset sales structure avoids many of the issues that you would otherwise have if you were just buying the underlying security, buying the underlying ownership. So it allows you to shed those assets, and is perceived by the public to be a very good solution.
And then maybe let's flip that, right? So then there might be instances where you want to go through the court process to buy a distressed asset. Do you want to maybe speak to that as well?
Sure. First, we should just mention we're talking about 363 sales here, and that is 11 U.S.C. Section 363 of the United States Bankruptcy Code, and that's essentially a provision that allows for auction inside a bankruptcy case. And this applies to many industries. It applies to everything you can think of, from very high-tech to low-tech. Right now, we are working on matters that involve these 363 sales in healthcare, real estate, high technology, and hospitality going on right now, and we have them all the time. So why go into court? So there are advantages to the court process. One is to avoid successor liability. The successor liability doctrines are well formed under state law, but a corporate transaction outside of a bankruptcy case cannot assure you that you won't be challenged on that basis. The federal court bankruptcy order that you get, which has grown in size from during the length of my practice from about 10 pages to about 40 pages, makes sure that one of the things you buy free and clear of is successor liability. So that's very powerful. And you can also leave behind, very effectively, many different kinds of liabilities that would otherwise follow the company. And these could be taxes, product liability, environmental, employee claims, union claims are most typical, but it's any kind of claim you can think of. So those are some of the advantages, but there are more. Another advantage of buying through a process is insulation from fraudulent transfer liability. Now, people think of fraudulent transfer as necessarily involving fraud. Most times it doesn't. Most times it's just a sale for less than reasonably equivalent value that renders a debtor insolvent or is made during a time a debtor is insolvent. And generally, state and federal law provide for the asset to come back to the estate. In a bankruptcy case where you have a federal court order, that is not possible any longer. That's precluded by the good faith findings of the judge. So that goes away too. You can also obtain better protections than you can. Rep and warranty insurance is often touted as a very good solution to issues in corporate transactions, but there's nothing more powerful than a federal court order that says this is how it is, and that order becomes final. So that plus debtor oversight are also helpful. It's also important to remember that in the federal court system, in the bankruptcy system, when you have a sale, you do have this order to refer to. And the order will govern even over the APA. And you usually retain jurisdiction in the bankruptcy court. So the court that approved it has the court to adjudicate it, and obviously they're favorable to upholding the transaction. Even if it's overturned on appeal, there are protections available in the federal system, what we call 363M protections, which are good faith findings for the buyer that allow the deal to stand almost no matter what happens on appeal. Another advantage to in-house, to in-court, and again, it's more expensive and it's slower, is that you can avoid fiduciary duty claims. The beautiful thing about having a judge decide that the transaction makes sense and the transaction is fair is that you can't then second guess the court to sue the board of directors and the officers because there's already been a determination that was tested. So another issue that comes up sometimes is a post-sale transaction issue. Once you file a bankruptcy case, you know you're in a bankruptcy case. If you don't file a bankruptcy case and you're talking about a distressed asset, you could find yourself in a bankruptcy case after you sign a contract. The debtor has the ability to void your contract, essentially in the bankruptcy case, and so you spend months and hundreds of thousands of dollars or millions of dollars negotiating the perfect APA, and then they file, and then they reject the contract. And you have a damage claim that pays 10 cents on the dollar if you're lucky, or 5 cents on the dollar if you can establish a damage claim in the first place. At that point, in a hostile forum. So it's better to know you're in the case and you have the insulation of the case. Because remember that the asset's distressed, whether you're in the case or not in the case.
And I'm curious in your practice when either the owner of a distressed asset or the potential acquirer approaches you, early in the process, are there sort of key guideposts that you think about or discuss with the client before you try to pick the right path?
Well, always, and it depends. For example, there are many advantages to buying for example, in a bankruptcy sale. Not the least of which is how will exposure affect the price and affect the value of the assets. So if you're running a hospital, and we buy hospitals out of bankruptcy all the time, you would think the perception of a hospital in bankruptcy would make you go to another hospital. It's different than acquiring a shirt. So there's effect on the business. The second is the degree of legacy claims. The third may be taxes. A sale under a plan of reorganization, which can also be tied to a 363 sale, can be free of transfer taxes. So there are a lot of external motivations. Another thing is that the bankruptcy code allows you, and I'll get into more of this in a moment, allows you to transfer assets that are otherwise not transferable without the approval of the counterparty on the contract. That's just because of a special provision of the bankruptcy code. It also allows you to limit claims in a circumstance where you're rejecting, for example, real property leases. The claim, no matter how much it is for rejection, drops to the greater of 15% of the rent allocated under the lease, or 3 years, whichever is greater under the lease. So it tremendously brings down the claim, and then that claim is treated like all the other claims. So if claims are treated at 10 cents on the dollar, you've now gotten 2 reductions out of the same landlord, which is why you see so many retail bankruptcies. The other thing you can do is it allows for incredible flexibility, and it is a shame perpetrated by my bankruptcy community that we haven't better explained this to the public. And if we had, there would be more transactions that are effected this way. It's far less risky in many circumstances. The other thing you can do is you get this fantastic federal order that says that the sale is free of claims, liens, and encumbrances. That will stick absent a failure of notice, and usually that won't be visited upon the buyer. So your diligence can be lighter too because you don't have the same risks. And what happens is these claims and liens attach to the sale proceeds, and you can get the asset free and clear. So it's a way to maximize your recovery and enhance the certainty of closing the transaction. The other benefit here is that because you're necessarily in a bankruptcy case, you have the benefit of what we call the automatic stay, essentially an injunction against taking actions against the debtor while you're in the proceeding. So it's a way to calm things down and allow you to sell without the prospect of litigation around you that isn't at least concentrated in the bankruptcy court. That's another tremendous advantage. 363 sales also usually have expedited timelines. You can really get a lot approved. There's a theory of the melting ice cube. The faster you need the deal done, the faster the bankruptcy court will move, especially if there was pre-petition marketing of the asset. You can also buy what you want to buy and very explicitly leave behind what you don't want. You don't have to buy all the assets. You don't have to take any liabilities. That's just a matter of negotiation and contract. Again, as I said, very, very important, the ability to assign contracts and leases that have no non-assignment provisions in them. Absent some very interesting exceptions that aren't directly applicable to a general conversation, you can pretty much assign anything. And the debtor is required to select the highest and best bid, not the highest bid. There's a lot of discretion in how to do that. Often the highest bid the best bid takes into account things like employment. I've even had cases where national security was implicated. Where many years ago we were selling parts of computer hard drives, and the question was, did we want this to go to overseas or keep it domestically? And the U.S. Department of Defense showed up in court to argue in favor of our purchase, my client's purchase. That's one of the things that happens. There is consultation typically with the creditors committee, but other than that, the judge is the one that calls the shots, and the standard is only what is in the best interest of the estate, being reasonable.
Well, now I get to ask you probably my favorite question in all of the Financial Services University courses, but in our talks in advance of today, we talked about the role of a stalking horse, and I'm hoping you can explain to the audience what is a stalking horse and what is the advantage of being one.
So the stalking horse is the party that comes out and sets the table. There's an advantage to a debtor in having a stalking horse, and that a debtor knows that it will have at least one party show up. So it's like throwing a birthday party and having at least one guaranteed guest. So you know you're going to have that. And the stalking horse so that's the advantage to the debtor. The stalking horse has advantages too to itself. And we'll talk about more of that in a moment, but basically, depending on your relative leverage, if you're the only real buyer, you get to dictate terms, or you can say, I'm not going to buy. Now, those terms are not only the terms that you would think of, such as, what I put in my APA, my asset purchase agreement, but there are also other terms. For example, your ability to shape the process. Stalking horse bidders have input into at least the following things, if they are well represented. Milestones in the case, timing of a sale, timing of notice of a sale, where the sale gets noticed, who qualifies to be a bidder, how many bidders you can have, the form of the bidding, the minimum overbid, which is the first bid over the stalking horse bidder. Typically, that's enough to cover some other matters we'll talk about in a moment, but that's a significant hurdle. It can be very material. And then the successive overbids, and there's always a negotiation. The stalking horse bidder typically wants the highest minimum overbid, okay, and the greatest successive bids, because if nobody else shows up, there's no auction. You've gotten all the benefits of a protection of an auction without an auction, and the tension for the estate professional is to try to get the most competitive process going they have. So often they go to court with something that doesn't even look very realistic, and then they know the court's going to cut them down. But the more important part, and the part you hear about, are bid protections. Not only do you get to help dictate the process, which is more art than science, but you get to put things in there such as, well, what happens if I'm overbid? Can I get my expenses back? The answer is yes. Can I get a breakup fee for my time and expenditure of effort? The answer is yes. How much? As you can imagine, the buyer wants enormous protections. The seller wants minimal protections. There's a negotiation, but typically 3.5 to 4.5%. is typical for a combined expense reimbursement or breakup fee. Obviously, there's tremendous variation depending on the amount at stake and how much effort's really gone into this. Breakup fees also have to be approved by the bankruptcy court. So there's typically a hearing, and in these sale motions, there's typically two hearings. One is to set the bid protection, and the second one is to confirm the results of an auction or a non-auction, depending on whether there was another overbid.
And so, look, we've covered a lot in not a lot of time. I'm curious, sort of everything we've covered, and maybe even more than just that. If you want folks to take one thing away from this, what would it be?
Okay, so buying distressed assets is an art, it's a science, and it can be incredibly profitable. It can be as effective as neurosurgery, but you wouldn't perform an operation on your own brain, and you shouldn't look into a bankruptcy distress situation without trained professionals. It's dangerous if you don't know what you're doing, but it is incredibly financially rewarding if you get it right. That would be my one takeaway. Talk to somebody early, get advice.
Well, Jeff, thank you for joining me. This was really insightful.
My pleasure. Thank you so much.
So that does it for another episode of Steptoe Financial Services University. Today we dove into the world of distressed asset acquisition. You can watch more of our episodes and get more information about our financial services practice at steptoe.com. Please check out the other course offerings. And thank you for watching. We'll see you next time.